Ladies and gentlemen, good afternoon and welcome back to the CEFTA conference. We hope that all of you had a good lunch, those who are here in Skopje and those who are joining us online. Of course, we also hope that you managed to have a good lunch and a good break. And now you are refreshed with new energy to follow the third panel in the CEFTA conference. So our third panel refers to the intellectual property rights in boosting trade and investment in CEFTA. You have heard in the first two panels that were in the first half of the day today that trading goods and trading services are quickly developing in CEFTA, and of course you have heard also that some of the cross-cutting issues were discussed already, including the intellectual property, as you have heard today in the morning. On the customs side, there are new developments that on the risk profiles on IPR, and also, of course, trading services is also relevant in terms of intellectual property, as long as you think of buying things online or downloading music, movies, buying books online, and so on. You all probably are aware that CEFTA 2006 agreement has specific provisions related to intellectual property rights. And you also know that this has actually served as the ground for further work in CEFTA. The parties knew that these new, let's say, new areas of development are quite important. So they have actually included in the agreement all these provisions on intellectual property rights, so that this can further be developed together with the cooperation, of course, of all the authorities relevant in the parties. Today we will be discussing again and putting on the spotlight intellectual property. This is also relevant, as you heard again today many times, the common regional market. This has given actually additional boost for these cross-cutting areas of which intellectual property is also part of, as well as consumer protection, investment, competition, and other important areas that should be seriously considered if we want to develop a comprehensive free trade area in CEFTA, and we want to also the business to benefit from that and be able to trade easily and without any further obstacles. So I'm very happy to welcome the distinguished speakers today that we have also live here with us in the conference room, but also those who have joined us online. So I would first start, of course, with our distinguished guest who has joined us online, Mladen Vukmir. Mladen, of course, is probably many of you already know him and know his huge experience in the area of intellectual property and all his distinguished awards and so on. So I would just stop at saying that he's the president of the board of directors, Vukmir and Associates, and of course he is the key expert of the CEFTA intellectual property rights project that was actually launched this year, and Mladen and his team were actually working very have put a lot of hard work in developing the study that we will be discussing further today, and they have also provided recommendations and proposed solutions how to further enhance and develop the intellectual property in the region. Also, besides Mladen, Jasmina Suljovic is also here with us in the room. She's attorney at law and partner of law office Mirna Milanovic-Lalic and Jasmina Suljovic and Belma Derišević. So She is also one of the experts of the IPR CEFTA project. Then we have also Ignacio de Medrano Caballero. He is the head of Service of International Cooperation Service of EU IPO. We are very happy also to have Ignacio here with us in the panel. And we will be discussing actually today the more enhanced cooperation with the EU IPO and actually the 2 days of intensive discussions that were happening with the IP offices here in Skopje. So welcome, colleagues. Then we have further with us Dragana Ranitovic, the Head of Department of Intellectual Property, Directorate for Internal Market and Competition from the Ministry of Economic Development of Montenegro. So welcome also. We know that there were, of course, important discussions taking place during this week, so we would be looking forward to also hearing your experience as part of CEFTA party and Montenegro as well. So we have also Mr. Georgi Filipov. We are happy also to have you here together with us, the president of the governing body Intellectual Property Agency Berin, North Macedonia. Of course, you have a huge experience not only in North Macedonia but also outside North Macedonia and European Union. So we are also very keen to hear your views and your, let's say, position on how intellectual property would be, let's say, developing in CEFTA. We have also together with us online Ms. Maria Božić, the Assistant Director of the Department of Distinctive Science Sector, Intellectual Property Office of Serbia. So welcome, Ms. Božić. And since we are together now on this panel, I would first want to ask actually all the panelists in terms of whether or why do we need to take seriously the role of IPR in economic development, boosting trade and attracting investments? Why should CEFTA consider that an important factor in developing trade and boosting economic development and so on? So I would first probably like to start in a kind of reverse order with the colleagues who are here live in the panel, and then I will give also the opportunity to the colleagues who are online to present very shortly their opinion. Of course, we just need a very short view on that. So, Mr. Filipov, if you would like to start first.
Thank you very much, Mr. Chairperson. Yeah, Aurelia.
We can.
Yeah, it's okay. Do you hear me? Okay. I would like to say welcome to all of the guests here in the Republic of North Macedonia in Skopje. I hope that you are feeling yourself very good, although the weather is not so good. But we have another job today to discuss intellectual property in the countries of CEFTA and to give an answer to a very interesting question: why the intellectual property is so important, and why do we think that we have to take it very seriously? It's enough to look. I have one picture here with me, if it's possible, for the this picture shows the values of the first 20 trademarks or brands in the world. On the first place is Apple, with evaluated price of the brand $408 billion US. It's enough to take a look on this picture that shows the values of the first 20 brands worldwide to understand the importance of the role of intellectual property rights alone and expressed through only one of its elements, trademarks. Thousands of patents are hidden behind the identity of this most valuable brand, Apple. In one trademark of the brand called Apple, for example, in the trademark iPhone 11, I have this one with me, which is one device. I say device because it's not longer just a phone, but also a TV, a gramophone, a recorder, a camera, a calculator, a computer, and many other things. It contains maybe 2,000 or 3,000 patents inside. And the trademarks and patents in the trademarks, as we know, are elements of industrial property, of intellectual property. And only one of the founders of Apple, Steve Jobs, there were two of them, two Stevens, was the author of about 320 patented solutions built into his, I would say, his magic phones. Apple's annual gross turnover exceeds the GDP of many countries around the world. The most of them are very serious countries. The question arises, what is the main characteristic of the company Apple? It is the most innovative enterprise in the world, which has adopted a new strategic brand management, a new approach to creating value of its brand through its intellectual property rights, which has attracted a lot of investors who, by buying its shares, have increased its value and competitive position on the highest level that was not noticed until now in the history of the world economy. Here, that was all up to me in answers to your questions. Why we should take seriously the role of IPR? I was trying to answer intentionally using one example instead of a lot of theorizing. Thank you very much.
Thank you very much. Dragana, please, just very shortly, of course.
Hello from my side too. Thank you for the invitation and for the opportunity to be the active part of this event. Why it is necessary to take seriously the role of IPR in the economic development of each country is best shown by economic indicators, which are from the Center of Protection of Intellectual Property Rights in Europe and the world. Namely, industries make intensive use of intellectual property rights such as patents, trademarks, industrial design, and copyright, and they generated 45% of the GDP in the EU annually and account for about 63 million jobs. In addition, 21 million people are employed in the sector that supply these industries with goods and services. IPR-intensive industries also account for most of EU trade in goods and services, with the other regions of the world about 81%. The EU as a whole had an overall trade surplus in IPR-intensive industries of approximately 182 billion euros. And the report finds that industries making intensive use of patents employs some 24 million people and generated 16% of EU's total GDP. Having in mind the above, the importance of IPR in the economic development of the country as Montenegro might be considered as a conditio sine qua non. We cannot talk about significant economic progress without IP. Thank you.
Ignacio, please.
Thank you, Aurelia, and thank you to CEFTA for inviting EUIPO to be here with us. The answer for me is very clear. I mean, innovation and creativity, they are a key component for growth and for a sustainable economy. This is something that we see very clear. The intellectual property is nothing as such. It is just an enabler. It's a facilitator for this creativity, for this innovation to boost and to be something, an intangible asset that might be used by the economic operators. This is what we see. The study that has been already mentioned by my colleagues here at the stage have very clear figures, and this is something that we have been with some studies developed it at the EU IPO together with the European Patent Office at the European Union level, give a lot of importance because we think that figures, something is to say that intellectual property is important, but maybe we have to have some data, and this data that has been just mentioned, and maybe just to give another one, if we compare those companies who have some investment on intellectual property, those that have not protected its assets with intellectual property, the difference is on revenue, for instance, is an average of 20%, and it even arrives at the level of SMEs at 55%. I will not be any more long, but it's an additional figure to show how for us it is, we consider that it is something, as I said, a facilitator for innovation and creativity.
Thank you for having me here, and I would answer with the question. I think it's really important that we ask ourselves how the world would look like if we don't have intellectual property rights. So actually, I will add also what my previous co-panelists have just said, is actually, to me, one of the main answers, and it's not only answer actually, is the innovation. Because of the innovation, you actually have more funds going to research and development, and then actually through intellectual property rights, you have the ways to protect and enforce that innovation. Then you can actually help SMEs and also larger companies to monetize on that innovation. Also, intellectual property rights help you actually to distribute and disseminate that technology, and in the end, you actually, not just that the companies benefit, but also actually the society and all consumers benefit from the IPR. Just imagine how the world would look like without one Apple or without actually intellectual property rights. Thank you.
Let's move to Ms. Maria Božić now, and here have views on why intellectual property is important, especially for economic development and boosting trade. If she is together with us.
Good day to everyone. I hope you can hear me. I would like to share a couple of thoughts about protection of IP rights. I think that it creates safe business environment and stability and enables economic development of the whole society. IP rights are very valuable asset for every company, and the protection of IP rights enables creative people to really make a living from their work. Also, strong IP rights help consumers to purchase safe, reliable products and products of the known origin. Biggest problem in the protection of IP rights is piracy and counterfeiting, which are very damaging to the economy. These are just a couple of thoughts for introduction. Thank you, everyone.
Thank you very much. And now let's move to Mladen. Actually, I left Mladen, for dessert, because he would be also, besides the first question, he would be following up with the second question, actually, which will be answered in more detail. So, Mladen, can you hear us?
Yes. Thank you, Aurelia, very much. Thanks for having me, and sorry not for being with so many friends and acquaintances in Skopje and on stage, as a matter of fact. In terms of adding to the dessert, I think this would be a fifth dessert in a row, because all these answers are fully pertinent and totally explain what is really the reason why IPRs are so important. And indeed, the answer is in your question. It is so important because it guarantees economic development. And here in Southeastern Europe, our countries have some kind of a transitional jet lag. We were for a period of time, we were wrapped in a bubble where our economies, our companies did not realize how important it is. And exactly the integration processes, such as CEFTA and the EU integration processes, help our economies create well-being, create wealth for our populations. And today, the economic development depends on many factors, admittedly. But one of the main is intellectual property. And if we don't have the IPR systems functioning, we cannot get where we want to be, meaning well off. And this is why it is so important.
Okay, so as a follow-up, actually, one of the main questions that we want to hear also your answer and your team's answer is that, of course, this year you were involved as a key expert in the CEFTA IPR project. You have actually assessed the IPR systems in CEFTA. So what, according to you, would be the main findings that you would like to share with us, that you would like to highlight? And how do you see actually the trends of evolution of the IPR in the region, and whether you saw some good practices that, could be replicated for the region?
Thank you. First, a general remark, I have said on the first day that I am, in a way, a big fan of integration for various reasons. I have seen other parts of the world. My wife is from Argentina, and I have seen their efforts to integrate. And I was primarily Mercosur that was mentioned today earlier in the sessions. But I have seen how efficient European integration model is. And I really think that every effort that we put there is some of the most noble efforts which we as individuals can make in our times. We must integrate for the benefit of our societies and for our own. And therefore, it was a great privilege to work in speeding up the integration efforts of my part of the world, which was for various reasons left out so far, is behind the general European integration level. Having said that, we were happy to see how much has been done. I will let Yasmina complete the details, but a lot of elements of first obviously TRIPS and then even the EU acquis are already in place, showing that the parties have done important steps on their way of raising their economies to the level of being able to integrate. And some of the things obviously did not come as a surprise. They are also common to the area and to some other later entrants to the EU. Some problems with fine-tuning the efficiency of enforcement agencies. One particular thing that we have seen in CEFTA is a lag behind the efforts that EU member states have made in small consignments enforcement, which is a general trend coming on top of the enforcements, and obviously also digital commerce issues which are connected with IP very often. There are needs to further improve efficiency of judiciary, to ramp up the standards, and especially time-wise. What I have grown up in my country with the tendency of courts to discuss law instead of deciding. Law is not there to be discussed. It is to be decided. We have to be operational. We need decisions to stop the illicit trade. And this is something that needs to be done. This means specialization and concentration of competencies of the courts. I can go, without going into details, I can go longer on, but as I said, I think that Yasmina will complement well with my answer. I don't want to take
Thank you,
more
Mladen.
time.
Thank you, Mladen. What we've seen so far is that when you look at the legislation of each of the parties of CEFTA, you've seen that so much has been done and that laws are almost aligned to the EU acquis. What we, on the other hand, have seen that not so much of implementation in those laws has been done. And we've also seen that there's a lot of untapped potential in terms of further cooperation between CEFTA parties. That's why one of the key recommendations of our study is actually to establish a subcommittee on the intellectual property rights that will facilitate cooperation between CEFTA parties. So much can be done in exchange of knowledge, in exchange of different practices of enforcement institutions, and especially in terms of, as already Mladen has said, in terms of judicial enforcement, because we've seen that main issues actually are related to enforcement in courts. So many things can be done there. And also when you asked whether have we seen good practices, I would definitely say that we've seen many good practices in CEFTA parties. And one of the key messages for me, actually, especially after spending 2 days here with the all IPOs from CEFTA parties, is actually that the key component are actually people who work in IPO offices, and that we have very good people in IPO offices working. Of course, there's a lot to be done in terms of capacity building because there's not a lot of people and we need to attract talent, but we already have a good basis for what's needed to be done in terms of our parties to actually align ourselves with the EU acquis, but also to further cooperation between ourselves.
Yeah, that's very, very interesting to hear, and we hear that many positive aspects that you were able to assess, that the parties are quite well advanced in this area, but of course there are still many issues to be tackled and to be, let's say, planned and resolved. And I think what you mentioned in terms of the, let's say, a proposed CEFTA body also. We were discussing, of course, on this, legal framework that should be also developed in intellectual property in CEFTA, so that we, let's say, lay the ground for, for further work and actually identify the trends and the actions that need to be taken further by the parties. So let me move also now to Ignacio and also, of course, say that this year was actually marked with a much closer cooperation between CEFTA and EU IPO. We managed actually to initiate a number of activities and a number of good positive practices that we hope should continue in future. And again, as I mentioned, this is also very relevant to that CEFTA framework on intellectual property that was discussed actually quite intensively these last days. So in that respect, how do you see the potential of IPR development in CEFTA, and actually what would be the role of EU IPO, in developing joint rules and standards in CEFTA in intellectual property?
Thank you, Aurelia. Well, let me start by saying that, yes, we have started cooperation. We hope that it will go much longer and much bigger in the next years, and this is what we've been discussing in the last days here in this beautiful city of Skopje. For those who don't know, let me briefly just say what is the EU IPO in order to be able to answer to your question. We are the agency specialized on intellectual property from the European Union. Our main task is to protect at European Union level trademarks and designs who are protected in the whole territory of the 27 member states, and these rights coexist with the intellectual property rights that are registered at national level by the member states. At the same time, we are very much, let's say, focused on cooperation within the European Union between the European IP offices and the European Union Intellectual Property Office, the EUIPO, and also externally on non-third countries, and we have programs in very different regions, Latin America, Asia, Africa, And this is a little bit one of the reasons that I'm here. I'm responsible for international cooperation, and we are talking with CEFTA since some months, and we are trying to see if with the conclusions that has been taken, or they are starting to be developed at Mladen and Yasmina and her team, and the decisions that will be taken at CEFTA with their parties, to try to facilitate these recommendations that will come in order to provide some support on implementing those elements that, as we were saying, the EU acquis and the legal framework is about to start to be developed, but IP needs much more. They need that practices, that the companies have practices that are common and are easy. They need tools that facilitate the protection. They have a lot of elements that are needed in order that the intellectual property systems are enhanced and are improved. So that's where we are here. We come for trying to help, and we will, of course, do it very happily with our neighboring countries in a regional framework. That it is something that we've been doing, as I said, in other parts of the world. For instance, ASEAN. So we have already this vision of working together with different parties in the same direction, and I think this is good news that we are talking, and we are going to work together, I hope, in the next years.
Yeah, that's very good to hear, and we saw also the commitment and the willingness also of the IP offices in general in the CEFTA, that they are also quite committed and wanting to enhance this cooperation in the framework of CEFTA on intellectual property. So now let me move to Dragana and ask her whether you could share with us some of the policies and actions that the Ministry of Economic Development of Montenegro has undertaken in promoting and supporting IPR matters, especially for SMEs, and especially that, let's say, in your case, all these IP issues are actually concentrated in the Ministry of Economy. So please.
Thank you. Well, among the other activities, today I will point out the new one. A couple of employees have undergone several training organized by EU IPO and EPO during 2018, which concerned the issue of providing pre-diagnostics of intellectual property rights in the targeted economic segment. Also through to 2020 and up to the middle of 2022, Ministry of Economic Development was a contracting party and beneficiary of one project, EU IPA 2016, which calls promoting innovation culture and supporting collaboration between research, education and innovation actors. One segment of this project related to education and training a team of experts who would be fully prepared to respond to the challenge of valuing intangible assets of SMEs that express interest in this type of service. In that direction, within the pilot project, several pre-diagnostic visits to campaigns from different segments of activity have already been conducted during the September of this year. And the first report made by our experts have already been delivered. In those reports, we point out some recommendations for that SMEs. The next event will take place 18 December of 2021, and which will concern all the achievements of the Montenegro in the IPA segments in the past calendar year through the activities of the Ministry of Economic Development, and will dedicate one segment to the achievements in promoting and supporting IPR matters, especially for SMEs, to once again publicly promote its services to all stakeholders. So that's the newest, and I want to mention that, and we are a little bit proud to start that kind of service in our office.
Yeah, that's very, very good to hear. Mr. Georgi Filipov, recently the Western Balkan Sixth Chamber Investment Forum, they have published a report which has been presented today in the morning for everyone who was here in the conference and also those following online. So they indicate that intellectual property is ranked among the non-tariff barriers that are considered an obstacle to doing business in the region. So since your company, of course, is offering a number of services on intellectual property, both in North Macedonia but also beyond, also in European states, how do you think, what would be the added value for the business in protecting their IPRs without making it too cumbersome and without creating some additional barriers to trade?
Thank you very much for this question. I hope that all of the here present people remember themselves concerning this picture for these types of non-tariff barriers, NTB. The rules of origin is on the first place with 54.2 points, and the intellectual property as a barrier is on the 11th place. It's not so awful, it's not so dangerous. That was I would like to potential, because I read the explanation in the published report from Western Balkan 6 Chamber Investment Forum, in which was said that, I'm citing now, the results of the survey shows that the most relevant NTB obstacles for Western Balkans companies that reported barriers are rules of origin, non-technical measures, sanitary and phytosanitary measures, export-related measures, measures applied to exported goods by the government of the exporting country, pre-shipment inspections, and other formalities, as well as technical barriers. They are the most frequently obstacles. Intellectual property, as I already said, is on the 11th position, quoted with 15.3 points on the scale, where the rules of origin was ranked with 54.2. Even the color of the obstacles is green. That means it is not so dangerous barrier. Anyway, there are still companies which consider that IP rights can be an obstacle, even barrier. My personal experience as former director, inventor, engineer, director of Macedonian Patent Office or Industrial Property Protection Office, as professor also, and founder of intellectual property agency Berin, which exists almost 13 years, with own branch in Austria and partner companies in all CEFTA countries and European Union, Russian Federation, USA, China, Japan, Republic of Korea, Australia, India, Middle East and South and North Africa. I confirm even stronger. I am emphasizing that each company which takes care of its IP portfolio, protecting their IP rights, has benefits and added value for its business. The regulated IP rights helps to the efforts for developing of any country's economy and society, and it is a powerful tool for economic growth. The IP rights are not a monopoly of the owner, but award, protection and recognition of the IP assets, which was created by investment of a lot of knowledge, a lot of research and development activities, work, and a lot of finance. The IP rights facilitates production, national, international, and global trade and investment through various possibilities to exchange goods and services in kind of commercial sales, franchising, licensing, or turnkey projects, respecting the procedures defined by the World Trade Organization, World Intellectual Property Organization, and TRIPS Agreement, and better mutual management organization of the customs services in the member countries of CEFTA will improve trade with added value for their businesses. Thank you.
Thank you very much for this detailed explanation. We actually slightly delayed, so let me move quickly to Ms. Maria Božić and ask her how would you describe the IP system in Serbia and how it supports and facilitates the activity of business. And what success stories in utilizing IPRs in Serbia you want to share with us, or you have as an example?
Thank you for the question. I will be short since we don't have much time. I would like to say that IP system in Serbia is based on IP laws, which are largely in the line with EU legislation. Recently, amendments to the long patents were adopted, and some legislative changes to the long copyright and related rights are underway. IPO, this is the short from Intellectual Property Office, Republic of Serbia, conducts various activities with purpose to facilitate business activities in the field of protection of IP rights. Part of office is Education and Information Center, which has been providing service IP diagnosis since 2010, which is aimed to support businesses, and it involves assessment of all relevant factors relating to the IP rights of business entity. The assessment shows capacity of business entity and can be used for its development. Only this year, 28 services of IP diagnosis were provided, of which 25 services were provided for SMEs and 3 for teams from scientific research organizations. Since 2010, our office has been provided for a total 455 services for SMEs and other users. As the consequence of this service, only this year, 5 applications for protection of inventions, 11 applications for industrial designs, and 58 trademark applications were submitted. During this year, IPO was very active, and it provided consultations for 4,016 parties, of which are mostly businesses. Most of the questions were related to the trademarks, and then patents and copyrights and related rights. This year, like previous years, IPO participates in trade fairs, and this year IPO participated in agricultural trade fair in Kragujevac and ethno-food fair in Belgrade, and on these fairs consultations were provided from the office to the visitors and to the exhibitors of the fairs. I would like to say only shortly, our office has a very informative website with online databases, free to use informations and instructions about applying for IP rights. We have a possibility of electronic submissions for all IP rights, and not only applications, different submissions which are in rise because of various activities IPO conducted, especially when we lowered the fees for application, and subsequently we had the increase in the number of applications. I would like to say only at the end that IPO plans to improve and further develop activities in the field of education about IP rights, cooperation with businesses, and facilitating economic activities. Thank you.
Thank you very much, Maria, and it's good to hear indeed that so much work has been done, and you are actually supporting so much, the companies to be able to benefit from intellectual property and be able to register and to know exactly how important that is. So let us move, since we have some around 10 minutes, let's say, left overall of our panel, let us move to our, second part, where we just, I will give you the question where we can more freely discuss and share our opinions and our views. And probably Mladen now he can start the second part in asking how do we ensure that the joint rules and the minimum standards for protection and enforcement of intellectual property rights among CEFTA parties serve their purpose without generating unnecessary costs and possible barriers to trade? And how do we go about the concerns of the business that the rights obtained on one market are not valid in another CEFTA market, specifically referring to trademarks? That, again, as I referred earlier, was mentioned in the Western Balkan Six Chamber Investment Forum report. So, Mladen, can you share with us your opinion on that?
Thank you. It is relatively too easy to answer, and this is not a miracle. It is because we have the European model. I was watching the other parts of the world in their integration efforts, and without such a powerful model and tested model, something that really works, it's much easier to get lost with this huge effort that it takes to bring our societies globally to be a modern, functioning, contemporary, innovation-based societies. So for us, following the model that has been tested and has proven to work, and let's not underestimate the monumental result that we have. After all, European Union is only supranational IP jurisdiction, territory in the world. Sometimes as Europeans, we underestimate the achievements which we made, removal of borders, removal of barriers. Here, if we follow this, I think we have an advantage. And in a world that is so competitive, this advantage that we are trying to pursue and trying to use to bring us to the forefront is something that we need to follow. Regarding your question, the concerns, I think that the concerns from the movie that was played before the panel started, we have seen how well informed can companies be when they decide to go into the markets that probably 10 years ago they were not even considering and were not familiar with. They do get informed. So working together between the public sector and the private sector in making room for innovation-based economy to thrive is the way to go. So the concerns will be best addressed by the players themselves, because this is what our human endeavor, entrepreneurial efforts can bring us to, with the help of public sector, and then in conjunction working together in bringing shaping the new market conditions that are necessary for businesses to progress and thrive. Thank you.
That's very interesting that you mentioned that indeed the companies are informed, or they want to be informed when they access new markets, those that they didn't know before. I was wondering actually, and maybe Ignacio can also share with us, how do we help then SMEs, because they might not have all the access to some information, or their capacities are quite limited compared to bigger companies who can allow, to hire some lawyers or to approach some consultancy services to be more informed on the other markets in this area. What do you think on that?
Thank you for the question, Aurelia, because in fact, in the last 2 days, we've been discussing specifically among the IP offices that we have been gathering here in Skopje about this issue. I mean, SMEs in the European Union, on the CEFTA parties, everywhere it is one of the elements of the key drivers of our economies. This is clear. And most of them, or many of them, they do not get advantage of the intellectual property. This has also been, with some of the studies that we have done, identified that it is an issue. In fact, at the EU IPO, in my agency, the strategy for the next years is trying to support as much as possible SMEs and to integrate them because we know that it is beneficial for the SMEs, not because of the reasons. Specifically on the question of information, that it is essential. I mean, if you don't know how or what you need to register, what you can protect, and if you have some assets that can be protected and they have an economic value, the SMEs are losing a lot of economic value in general terms. So what we were discussing as a possible action in the future with a program is to set up an IPR SME help desk. That should be some information provided to any company, European company, that want to invest in any of the CEFTA parties, and now how to protect its trademark, how to do in order to have some information about what is the elements that they have that they can protect as a design, what kind of creativity can be also taken as an asset. So all these things to help and to assist SMEs to understand what they have and how to protect it, and eventually, if they have a specific problem, how they should go and to whom they should address if they need to enforce what is being protected by them.
Yeah. Mr. Filipov, would you like to add?
Thank you very much. I will be more direct in my answer than the Mladen and Ignacio said. It's not, you had very directly questioned that the small and medium enterprises and other enterprises are concerned about the possibility of one trademark in one country to be recognized, in another not to be recognized, and it is against the rules, and it is a pity for the economy, for the business, and so on. And the both of them didn't say anything about that. But I'll start with the second part of your question. Concerning the second part of your question, I agree with the statement that we should concern because of this possibility, because we as IP representatives, there are some of them here also, already met some, not many of them, but some cases where one country's national IP office has misused position expressing it by refusing to recognize trademark owned by CEFTA and other CEFTA foreigner applicant with purpose to expel the applicant company from domestic market.
Mm-hmm. So
unfortunately, there are cases, not too much.
Mm-hmm.
Thank to God. Unfortunately, we have similar situation and experience with the European Union Intellectual Property Office. Ignacio, nothing personally. I'm just, even it's not recommendable to mention examples, but there are cases when one geographical name or indication is part of the trademark, sometimes, where the trademark's application is asking to be recognized in graphism. In these cases, EU EPO is regularly on the site of member states in EU. Maybe it's a rule, but maybe if we were a member of the European Union, we are not going to speak like I am talking now. But in these cases, they are neglecting the spirit of Paris Convention, its provisions and articles. In conversation with my friends from the former Yugoslav countries, which are now European Union countries, also former neighboring countries, which are now European countries, they just said to me, do not worry, it was similar when we were outside the European Union. Anyway, we are sure that these mentioned exceptions are not a rule, and we have a lot of applications before the European Intellectual Property Office, which is everything is okay, even 98% of them are okay. It's not a rule, neither in each ECTA or CEFTA country, nor in European EU EPO. And still I believe that in order not to concern too much about possibility, one trademark with obtained registration in one country not to be recognized in another country, there are two possibilities to escape from these cases. The first one is to accept the fact that industrial property rights are, as trademarks is territorial assets. It is in accordance with Paris Convention, and we can do nothing against that, but to accept the rule, first applied, first receive protection at home and in the other countries also. The second possibility, maybe somebody mentioned, I was included from the very beginning in this project. The second possibility is to establish a CEFTA Trademark and Industrial Design Office. I will repeat, a CEFTA Trademarks and Industrial Design Office, following the example of Belgium, Luxembourg, and Netherlands, which have positive experience. It will be fully in line with the initiative Open Balkan, declared not long time ago by Albania, North Macedonia, and Serbia. Thank you.
Thank you. Ignacio, would you like to add anything on that? Or?
Absolutely.
Yeah?
Very happy to do it already. Indeed, I mean, it comes very much in line with things that we have been discussing. The territorial scope, that of course it is one of the main elements of the IP rights, is there, and I totally agree that we cannot escape, and it's the scope of protection of each of the rights. But there's something what I don't agree is that there's not something that we can do, specifically the administrations, the IP offices, and that's what we have been discussing. And this is when the legal frameworks that each of us we have on our different countries, at the European Union, and in many of the cases they are quite similar. Yeah. But what it is, the divergence doesn't come from the legal frameworks, come from the practices of the offices in many occasions. And this is something that we realize at the European Union, having problems as the one that you mentioned between having different results, one office from the other inside the European Union, not outside inside. And for this, for years and years, we've been discussing, trying to converge and trying to avoid these discrepancies in the practice of the offices. And this is something that I think we can do it also with CEFTA parties. And something that can be done, and it is already done, is this kind of discussions in order to avoid problems that come more from the practice, administrative practice of the office, as I said, that from real difference on the legal frameworks between the countries. Thank you.
Really, may I ask only 1 minute?
Just very, very shortly, we are actually running out of time.
Yeah.
So we just
as
need
you
to
have heard till
up.
now, we have a so-called PRESPA agreement with our neighbor Greece, and the two members of this international group of experts, which facilitated the conversation between the business communities from the both sides. WIPO already gave one expert to help us, to help to this group. But from EU EPO, we are still waiting for one name from the EU EPO who is going to help us in this, trying to find some solutions, even there are not big problems between business communities concerning trademarks and geographical indications. Please just converge that we are still waiting for the name. Thank you.
I think the discussion can continue outside already the panel. So thank you very much to all the speakers, all the panelists who were here today with us. I think we gave also for the audience and those who are following us online, food for thought and more information on actually what is happening in this intellectual property area and what are the next steps that should be done in the CEFTA framework. Sorry that we couldn't actually take some questions maybe from the audience, but indeed you saw the discussions were quite intense. So thank you very much for your good ideas. I think these ideas that we discussed even today should be taken further, and this will be discussed in the format, as we said, of intellectual property offices and the other relevant institutions and authorities in CEFTA. So now we will have the final, let's say, the closing of the conference. So we looking forward for you to follow that. So thank you very much once again, and have a nice day. Bye bye.
Thank you.